Okay, everybody, welcome back to Call to the Bar podcast. And this evening we are joined by Lee Fish, who is a criminal barrister at New Park Court Chambers in Newcastle. I did a mini pupillage with Lee, so that's how I managed to make that connection, where I actually observed a rape trial that Lee was prosecuting. That is going to be the crux of discussion for this evening's podcast episode. It's going to be all about rape trials. And Lee has kindly given up his time. Also, just worth noting a little bit of an interesting point. Lee also has specialist area in environmental regulation, which I then learned that is actually still crimes, but to do with the environment. So it's still a defence and prosecution ran procedure as you would see in a court, but it's just to do with environmental problems and impacts on the environment, if I'm correct in saying that. And yeah, so you are also on many different panels, and I've got that on Chambers' website. There's so many to list. But one of the panels that you are on, obviously, just a bit of by way of introduction as well, Lee, you do prosecute and defend serious violent cases and sexual assault cases and rape cases as well. I know that you have done a couple of murders and drug conspiracies as well. I think I've seen on Chambers' website. So out of curiosity, is there any offence that you enjoy doing the most?
They're all different. They all bring different challenges. They all test your skills in different ways. Homicide is really, you always feel as though there's the most at stake, albeit there's always a lot at stake in most criminal cases in the Crown Court. But I've always really enjoyed the homicide cases that I've done, which included me doing my first ever homicide case on my own. Just before Christmas, I prosecuted a manslaughter, and I quite like those cases. I think really it's variety. There's no, I don't have a preference. It's just I think every barrister, if they're being honest, would like a bit of variety, and that's what I really like about doing different things. I mean, at the moment, I'm in month 3 in Manchester of a large conspiracy involving a significant organised crime group, where that's trading in drugs, guns, and arranging to have people killed. So that's what I'm involved in at the moment. And then I'm back in Newcastle dealing with some sex cases. So it's a variety. I probably don't have a preference. I've always enjoyed the homicide cases that I've done, if I'm brutally honest. If enjoy is the right word, I hope everyone knows what I mean when I say that.
Yeah,
But yeah, I don't have a preference. I think all these different cases, they test your skills in different ways.
absolutely. And you've got some experience in fraud as well. I think is it
A
fraud?
little bit, yes,
Yeah.
yes, yes. I have done a bit of fraud as well. I was successful this year in being appointed to the fraud panel,
Yeah.
fraud panel at level 3. Um, if I'm brutally honest, I wouldn't say I have got. I think I've probably got more experience in other areas than I do have fraud, but I have done some fraud work. I represented a woman a few years ago who was said to have effectively been abusing a power of attorney and stealing from her mother, and that was actually quite complicated for various reasons. A case I always remember is I prosecuted a couple of builders, rogue builders, who were effectively going around ripping off old people, sort of turning up and saying to them, either saying they needed to spend thousands of pounds to have work done, which they didn't need to have done, or if they did need a little bit of work done, saying, you've got to spend thousands of pounds and replace your entire roof when maybe, and then the work they did do, they weren't doing it properly. And they were targeting basically vulnerable elderly people living on their own, which quite mean offending. That's the law,
Mm.
so the law, I think. And that was quite an interesting case, and we got convictions against the builders who did it. But yeah, I'd say that's probably one of the most juicy fraud cases I've done, because it was fraud, because it was effectively them misleading the elderly people in terms of what it was that they needed to do. And the MO would be the turn up, and they would suggest that there's a possibility they could end up being taken to court, and they were basically it frightened the old people into thinking, oh, we've got to get this sorted and we've got to pay thousands of pounds to do it. So yeah, so
You hear
that's
far too much, don't you? It's constant that these little small businesses are constantly, no, not all of them, but there's a lot of them where you've heard it repeatedly in news that they're going and targeting old people. It's just so hard,
yeah.
isn't it?
I mean, I think these defendants, I think to say that they were running a business is probably to flatter them slightly. They were just
Yeah,
rogue. They were just rogue builders, and
yeah.
one of them before as well. So no, I remember that case quite well because it had a number of challenges associated with it, and you know, whenever you're calling elderly, vulnerable people, that brings with it its own complexity and its own challenges. But we got through it and we got a positive result at the end.
Oh, that's fantastic. And in terms of obviously all the different areas of expertise you've got and all the different types of offences that you either prosecute or defend on, the evidence that goes into preparing those trials on either side, of course, it'll be so different across the board. But is there any offence that has the most like content-heavy evidence, where that takes a lot of your time to read through, or is it all completely case by case?
It's completely case by case. Some sexual offences are very, very paper heavy. Quite often with sexual offences, what you'll find is that the actual evidence isn't that voluminous,
Okay.
maybe a couple of hundred pages. Where the volume sometimes comes in with these offences is where it's the what's called unused material. Just a quick explainer. In any criminal investigation, there will always be material that is obtained during the course of that investigation that doesn't form part of the evidence, but it has to be retained, it has to be scheduled, and in an appropriate circumstance, it has to be given to the defence. Now, in the defence, quite often that material can be quite voluminous, particularly when you're looking at sexual offences where you've gone through possibly years of social services records, medical records, education records. You can get quite a lot of material. So I think with sexual offences, the evidence itself quite often isn't that voluminous, although it can be, depending on the case, but generally speaking, it isn't. But there can be genuine volume in the unused, and quite often there's quite a lot of important material in the unused because even if the prosecution don't want to use it, the defence might want to. So yeah, fraud, obviously, generally speaking, your bigger frauds are incredibly voluminous. The type of case I'm doing at the moment is incredibly voluminous because it's multiple defendants. It's 2 operations that have been put together. I think it's 14 defendants in total. So you can imagine in a case like that, the case runs to hundreds of thousands of pages, which is why there's a prosecuting team. I mean, that is too much for one barrister to have to deal with. So there's me, and I'm being led by King's Counsel. And then we've also got the prosecution CPS team behind us and the police team. And it's very much a team effort because you've got to have a whole team because one person just can't be expected to manage that amount of material on their own. So I think that the answer to your question really, Ellie, is different cases bring different challenges in terms of volume and the level of preparation and the amount of material there is to read. It can vary, but some cases can be incredibly substantial.
And we'll get onto that a little bit later throughout the episode, specifically concerning the sexual offences and the rape trials, in terms of what that evidence looks like and what you may expect to see in terms of evidence in those cases. But do you think across the board, the reason why, again, I know it's case by case, but the reason why they might be a little bit less heavy on papers and things is because it sometimes does tend to just be a word of mouth, one person's account and another person's account. In some cases, with sexual assaults, there isn't any forensic evidence. Is that maybe the reason why?
I think you entirely hit the nail on the head. For a lot of those cases, you will often be dealing with effectively evidence that emanates from one person. That I think in sexual offences, more so than any other type of offences, that is not an unusual scenario. So I think you've hit the nail exactly on the head, where that's why there may not always be the volume of material that perhaps people would expect, because, as you say, most of the evidence is what they told the police when they were interviewed. You may well have a couple of witnesses who they may have disclosed to in the past. Often that's it. It's when you get into phone evidence and things like that when the volume starts to increase, which is it's becoming more common. But yeah, in a long-winded way, Ali, I'm agreeing with you. I think it hit the nail completely on the head as to why, in Russell cases, sometimes the volume isn't as much as perhaps people would expect.
Yeah. And in terms of the unused material that you just touched on a little bit there, say, for example, in the medical records and in the social services reports or in the secondary school reports and things like that, obviously, if something was found relating to the offence, then of course it would come out of the unused and it would be used as evidence if the prosecution decided to use it. Is that right?
Yes, I mean, it depends what it is. If, for example, someone disclosed, let's say it's an example, someone says that they were abused by a relative.
Mm-hmm.
If there was in that material, for example, someone disclosing to a teacher at school or something like that, that's evidence you would expect that you would use. And that is the sort of things you can find in that sort of material. So yes, and that's often barristers are asked for their advice as to whether should we use this, should we not, what should we do with it, and that's how we help to try and shape things to present the best possible case we can evidentially. But yeah, yes, there will always be times where you'll find material there that you end up using.
Yeah. And I know that you do prosecution and defence, but you do, from what I've seen on James' website, and I'll stand corrected if I'm wrong, a little bit more prosecution. I'm sure you are an amazing defence. Well, I know you are because everybody talks about you on the circuit. You are the famous fish. But in terms of prosecuting, I really, really want to ask you this question. Sometimes if a case comes through to you, I know that there's a stage procedure within the CPS to see whether it's got grounds and I don't know the actual terminology is, but see if it can get conviction. But has there ever been times in your career where you've turned around to the CPS and said, what the offence on the indictment is going to be a difficult one to pull through?
Many times. It's part of my role.
Yeah.
I think it's one of the real strengths of the system that we have, that you have a case which is investigated by the police. The CPS then make a decision, and then it comes to a barrister who looks at it with a completely fresh set of eyes, and it is part of my role. If I do not think that there is what is the correct terminology is a realistic prospect of a conviction, that is the test. So that doesn't mean definitely 100% there will be a conviction, because if that was the case, you would never prosecute anyone. But reasonable prospects that there'll be a conviction. Also, there's the public interest. You always have to think about the public interest. But generally speaking, if someone says they've been the victim of sexual offence and there's evidence to prove the defendant is guilty, there won't be many circumstances where it wouldn't be in the public interest to prosecute. But to answer your question, yes, it is part of my role, and it's something which I've had to do. And sometimes people disagree within the prosecution team. I've had police officers disagree with me. I've had reviewing lawyers disagree with me. And that's fine. I can take it. I'm a big boy. I don't mind. But it is my job to give my honest opinion. What I often say to the prosecution, and what I also say to defendants when I'm representing them, is, and I think this is a really important part of my role, I said, what is the point of having me if I'm not going to tell you what I really think? And I'm not going to give you honest advice. I'm not going to give you the benefit of my experience. If I'm just going to agree with you all the time and not exercise any independent judgment, then what's the point of me? So I think it is a really, really important part of a barrister's role, whether you're prosecuting or defending, to act as a filter and be willing to be unpopular potentially and say, I don't think we're going to get home on this. And sometimes the prosecution have accepted that advice, Sometimes defendants will accept the advice you give them. Sometimes they will not, and that is fine. If the prosecution say we disagree with you, we actually think this case is slightly better than you're giving it credit for, then that is fine. I don't take it personally. You crack on and you do your best. But
Yeah,
it is an important part of my role. And but also, it's not just saying the whole case has to end. There's no way we're going to get anything. Sometimes you do get cases where you think, I don't think we can quite prove this offence, but I think we could potentially prove this offence. That happens as well, and that's another part of my role.
of course, because both sides are putting, essentially, whether you're defending or whether you're prosecuting, they're putting their lives. I know the prosecution will put their lives into it, but they're putting their trust into your hands completely, and your and integrity as a barrister, and is everything, isn't it? And also, like you've just said, that it's what's the point in you? It's a privilege to do this job, so it's a privilege to be able to be honest with it as well, and say, I owe you my honesty. You are the specialist in the case. What's the point in having a barrister if they're not going to tell you the truth?
And it's your job to give advice.
Yeah, of course.
You're not a nodding dog. You're not just there to agree or the path of least resistance. Whether
Yeah.
people want to accept that advice is entirely a different matter.
Mhm.
And we're all human.
Yeah, of course.
You will sometimes see a case in a particular way, and
Hmm.
I'm perfectly capable of having my mind changed, and it has been on
Hmm.
occasion. I'm not someone who says, "This is it. This is what I think, and that's it. I'm not going to listen to anyone, or I don't care what any of you think. You're all wrong, and that's the end of it." That's not the way these things work. But at the end of the day, it is my job to give advice. It is my job to tell people what I really think,
Yeah, of
and
course.
be willing to have my mind changed, which
Mhm.
I'm always willing to have my mind changed, because what I will always say is, "This is what I think. Now, feel free to tell me why I'm wrong." Sometimes then it's just sort of deafening silence. Sometimes they'll say, "Well, actually," and then it's a team effort. This isn't just
Mhm.
my show. It isn't just up to me, but it is part of my role to tell people what I really think.
Yeah. So, you being on the RASO panel, can you just tell the listeners and the audience what the RASO panel actually is?
Yes, it's the Rape and Serious Sexual Offences panel. It is a panel that was set up by the Crown Prosecution Service, and what it's designed to do is to have specialist advocates who specialise in being able to prosecute cases involving rape and sexual offences. It carries with it a requirement that you have to have done specific training in relation to there is a rape and serious sexual offences course you have to do, and then you have to continue doing that periodically. I think it's every 3 years. I'm pretty sure that's correct, but it's there or thereabouts. And what's designed to do is for people to be trained and experienced and have the requisite skills to prosecute these very, very difficult cases. So that's what it is in summary. There are grades. In reality, grade one, no one, grade one, whatever, because they're at the start of their career, no other reason, would ever be doing a rape or serious sexual offence case. Grade two, you might get to where, if you're on the RASO panel at level two, you maybe can do the lower level sexual assault. I'm not sort of trying to minimize any sexual offence, but I hope people who understand what I mean.
Yeah.
The sort of the lower level stuff, and then you get to grade three where it starts to get more difficult, and then grade four where you get the really horrible stuff and the really difficult stuff, and that's how the system works. And the Crown Prosecution Service really only want to prosecute people who are on the RASO list with their cases, but because of some of the pressures that exist within the system, in terms of the shortage of barristers to do this work at the moment, sometimes they will occasionally go to someone, obviously of an appropriate grade and level of experience, to deal with that case. But ideally, they'd always want to have someone on the RASO panel to do it. So I hope that's a reasonable explainer. It's just a
Yeah.
specialist panel, which was set up, and that the intention is that people on it have the requisite experience and training to do these cases.
And Actually, I had a similar thought in my head in what you've just said there about the lower level stuff. And again, I didn't know how to say it, so you've just worded it perfectly for me. And I'm not minimising anything neither.
No.
But where you talk about the like distinguishing features between the lower level stuff and the really horrible stuff, what type of things would you be looking at there to set them
Well,
apart?
you know, a low-level sexual assault where it's a momentary inappropriate touching over clothing. Now, I'm not saying that isn't serious. I'm not saying it's important, but you've got that on, that compared to someone who has alleging that they've been raped or they've been sexually
Yeah,
abused by a relative or by someone else. That's what I mean. I mean, all cases of this nature are very serious because they have really serious
of course.
consequences for the people who make the allegations, and they have very serious consequences for the defendants. That's the reality. But that's the scale, really. You've got the lower level sexual offending, indecent images on computers and things like that, what we would call non-contact offences,
Yeah.
offences where there hasn't actually been any they haven't actually physically abused anybody themselves, but may well have observed that online or sourced illegal material online. There's lots of examples now of the people who get caught speaking to who they believe were genuine children,
Yeah.
but they turn out to be either various organisations or undercover police officers posing as children
Mm.
online. So that sort of thing. But then you've got the more serious end, rapes, serious historic sexual abuse and the like. But the reality is, I think sexual offences is the one thing that was, as lawyers who do this day in, day out, we can apply a little scale to it. They're always very serious for the people involved on both sides.
Yeah, absolutely. And there are other factors that go into that. So, say for example, it would make it more of a higher grade if it was a child involved. For example, if it was repeated sexual abuse, or those different factors go into it as well.
Yes, that's it. That's it. I mean, there's no hard and fast rule.
Hmm.
Uh, I mean, the CPS will sometimes identify certain cases where they'll say we need a grade 4 to do this.
Right.
Because of its level of, either because it's high profile or its level of complexity. They will sometimes do that. But there's no hard and fast rule, but that's basically what it means. But there's no sort of list, there's no like
Yeah.
criteria that you can
Yeah.
apply. But there are 4 grades, and the reality is grade 4 is the most serious, and then we've got lower down the list, we've got grades 1 and 2.
So, was there anything in your career that kind of spurred you to become a specialist in this area? Was there any cases that you did on a whim, and then you've decided you wanted to go and become a part of the RASOL panel, or was it just a part of development in your career?
I think what you've said, what you've just said, part of development of my career is that I didn't come to the bar aspiring to prosecute and defend cases involving allegations of a sexual nature. It just sort of happened. My career just evolved in that direction. I started to do, as you would expect, started to do some of the more lower level stuff earlier in my career. I
Mhm.
defended my first rape at 7 years call. And that then it just sort of moved on from there. And I mean, I'm not very good at talking about myself, not very good at praise myself, but I think maybe it was just that there came a point where I was actually reasonably good at them. I had the skills necessary to be able to do them. And yeah, I like to think now that, that the prosecution now do trust, particularly the prosecution, but also the defence.
Mhm.
Um, I, I have in recent times been trusted with some pretty heavy cases. So, but that's only come from experience. But that was never. It's just the way things have evolved, just the way things have naturally progressed, really, rather than it being part of a plan.
Of course, and I guess with the breadth of experience that you've got as well, and despite it being potentially a little bit more prosecution instructing solicitors will still be able to know how much experience you've got in the area. And of course, you know, I know a lot of people say to me, prosecuting is really good because sometimes then you can see the cracks in the case as a defence advocate, and you get to learn a little bit more about the way it's going to go and what they're looking for, and you can kind of preempt what the prosecution are going to bring if you're defending. So, like you said, either way, you've just learned experience as a whole to be able to prosecute and defend these cases.
I completely agree, and that's why I think it's a really good idea to be able to do both. I mean,
Yeah.
some people just prosecute, some people just defend, which is absolutely fine. My
Yes.
career has always been, I think basically it started off where I did a bit of defending, then I got to where I was always more prosecuting. In recent times, I think it started to become slightly more balanced between the two, and I don't have a preference for either side. Both sides are different. Both sides bring different challenges. But I do think I'm a better prosecutor by knowing how a defense advocate might think. And equally, when I'm defending, I think I'm a better defender because I can sort of think how a prosecutor would think. And I do think that is quite a valuable thing to have up your sleeve. I just think it makes you a more rounded, better advocate. It is my personal opinion.
Yeah. It takes off just rose tinted glasses, doesn't it? And you can see it all for what it is, really.
It does. It does.
So, in terms of a recent case of yours that I saw on Chamber's website, it said that there were some difficulties with the Section 41 argument. So what? Sorry, not Section 41 argument. Section 41 evidence would it have been? Is that the? So what was? Sorry. First of all, do you see that quite often in those cases? Difficulties with Section 41, or can it be quite rare, or is it quite common?
Well, I think the first thing to say about Section 41 is that what it intended to achieve, I don't think anyone would disagree with. And that is what it was designed to achieve was that when someone complains of a sexual offence, and we will be straightforward about this, it's more often women than men, but of course men equally are victims of sexual offences. But what should not be permitted is for the defence to be able to just spend hours going through for no really good reason other than to potentially say that, try and create the impression someone is promiscuous or sleeps around, or all of those horrible things that may have happened 30 years ago. Section 41 stopped that in its tracks, and they said it is not appropriate to be exploring people's sexual history in these cases unless you have to satisfy very, very strict statutory criteria. So that the starting point always has to be Section 41 actually is what it intended to achieve is absolutely correct. I don't think there's many people would disagree with that. Unfortunately, it is a horrendously drafted piece of legislation. It is a really, really difficult piece of legislation, and it's a very difficult piece of legislation to apply in practice. I've been doing the job for 22 years, and when I'm dealing with bad character or hearsay, there are certain things where just experience, pretty much what the answer is or what the correct answer is. Whenever I am either drafting a Section 41 application when I'm defending, because you have to draft a written application, or I'm responding to a Section 41 application when I'm prosecuting, I can't think of any time when I've been able to do that without having the book open in front of me with Section 41, because it is such a difficult piece of legislation, and it's quite counterintuitive. It's not always obvious as to what the correct answer is. So the answer to your question is Section 41, yes, what it's designed to achieve, absolutely correct. No one would disagree with that. But in practice, it's one of the most difficult pieces of legislation to apply. And what that means is that quite often you find time is taken in trials trying to work out what the correct answer is. Now, sometimes, of course, it is obvious. Sometimes it is the defence just trying their luck at being able to try and adduce completely irrelevant material for no good reason. But then sometimes you get ones which are much more finely balanced. It is way beyond the scope of this podcast, Ali, for me to get into Section 41. And if I were to complicate it, I'd probably have to go away and prepare it because it is a really tricky piece of legislation. But it is something which frequently, for those doing these sexual offences, cases involving these sexual offences, it is without doubt one of the most difficult provisions we have to wrestle with. And I'm all for it being redrafted completely. I just can't help thinking there must be a simpler way of achieving what Section 41 is designed to achieve. But what do I know? I'm the one that just has to, on a regular basis, try and make sense of it, and it's not always easy.
Yeah, I think it's really, really useful though for young aspiring barristers like myself and many other people across the board that will listen to this podcast to actually know about it though, because I think that you actually it's not really taught at university as well, and I could go down a whole tangent about university and what they teach you, but I observed a Section 41 argument, and it was simply through judge marshalling, and if I hadn't have judge marshalled and saw that, I wouldn't have actually had a clue what it was. So I think thank you so much for explaining what it actually is and just actually making people alive to the fact that it is a really tricky part of even judges, like I may have mentioned before to you, but the judge that I marshalled that time was having a real difficulty over what to do because the real fine line over do I basically make this person look like a promiscuous little so and so, but that type of thing.
Yeah.
Difficult because she didn't know what to do.
I think most judges would probably say that it's probably one of the most difficult provisions they have to wrestle with on a regular basis. Bad character, things like that, quite often gut instinct, experience, you can find the right answer. I think bad character is a bit more intuitive. Hearsay, less so, but whereas there is nothing intuitive about Section 41. It is a horrifically badly drafted piece of legislation, in my humble opinion, and it means that for those of us having to try and apply it, it can be really, really difficult. I mean, I had an example of a case where Section 41, where the judge made a decision, but then found an authority which meant that the decision was wrong, but then found another authority that suggested the decision would be right. You can really disappear down a rabbit hole when it comes to Section 41. There is so much case law on it. If you were to say to me, what is the most difficult piece of legislation you have to deal with as a barrister, Section 41 wins without any hesitation at all. It is a horrifically difficult piece of legislation to apply. And that difficult for barristers, but I think it's also very, very difficult for judges, because in many ways it's more difficult for judges because what a prosecutor cannot do is agree to a Section 41 application. The judge you always require judicial leave. So it's the judges who are the ultimate gatekeepers when it comes to Section 41. So in many ways, it is even more difficult for them because they can't, as judges sometimes do, sort of just avoid responsibility and place it on the parties. Section 41, there's no way out of it, I'm afraid.
No, that probably is why the judge that I marshalled with was, pulling hair out in the chambers, thinking like, what the hell do I do here? For hours, and it really was for hours as well. And I witnessed this same judge. They were fantastic, really equipped, really competent, as most judges of course are, and they handled things expeditiously in most of the cases, but this case completely threw them. So it's so interesting that you've just said the same thing as well.
It's a section that keeps giving, and it's very, very difficult.
Yeah. So in terms of the fact that you are also on the North Eastern Circuit advocacy trainer, so that being you train pupil barristers, which they are required to do the advocacy training with trainers like yourself and other barristers across the circuit. So in terms of two questions, I guess I'm coming from this, what's the biggest advice that you would give to pupil barristers, and also junior barristers in an early part of their call, and what advice would you give to them directly relating to making a Section 41 argument?
Right. Well, first and foremost, my advice in terms of pupils is be yourself.
Mm-hmm.
Now, that sounds a bit of a cliche, but I think you have always got to be yourself. Don't try and copy other people. And what I always say to people is there are definitely wrong ways to do things, but there isn't only one right way.
Yeah.
I think that's really important to realize. I think one of the things that I often end up pulling people up on are things like when they try to overcomplicate things, try to use overcomplicated language, or we've got all people who have this image of barristers using wonderful flowery language and all of this. Well, actually, it's best just to use straightforward, simple language, because quite often you're dealing with witnesses and you're dealing with people who need to be able to understand what you're saying. So be yourself. Understand that there isn't only one right way. There is, of course, wrong ways. That's, of course, right. But there's only one right way to do something.
Mm-hmm.
And don't overthink things. Now, as someone who over the years has been a dreadful overthinker, I'm much better at it now than I used to be. So I'm sort of in a bit of a glass house throwing stones when I say that. But people, you overthink things, and it's just not healthy. Where quite often you'll find that your initial instinct's usually the one that's correct.
Yeah, and yeah, I'm an overthinker as well, completely.
Section 41.
Yeah.
Well, the advice I would give people is, and I've seen many. I read many very badly drafted Section 41 applications. And there are two things which I would advise any young barrister to do. Okay, if you want to impress the judge, if you want the judge to read your application and think this is someone who knows what they're doing, I need to take this seriously. First and foremost, a lot of people forget that in the criminal procedure rules, there are actually specific requirements as to what should be included in a Section 41 application. And very rarely do people do it. Very rare. I mean, just because it doesn't do it, you don't do it, doesn't mean it won't be allowed. But I always find that criminal procedure rules, and I can't remember exactly which rule it is, but it's definitely in there, that it provides the structure. It provides a really good structure. If you just follow, and then your application covers everything you needed to do. You'd be surprised how few people actually follow that procedure, actually follow the criminal procedure rules in terms of what is supposed to be in their Section 41 application. I'm not sounding pompous or anything like that. Everyone's working really hard and all of this. But, when you're dealing with a really difficult piece of legislation like this, structure and clarity are your friends. And I think the criminal procedure rules, just going through those, if you going through all the things that they say should be included in a Section 41 application, including the questions you actually want to ask, the amount of people who don't actually include in their applications. So what exactly is it you want to ask this witness? So I would say follow the rules, go to the criminal procedure rules, structure your application consistent with how the criminal procedure rules say it should be done. That's how I always do it. And then there is no easy shortcuts with Section 41. You need to have the section in front of you. You need to have the case law at your fingertips. There are plenty of practitioners' texts now, whether it be Archbold, Blackstone's. There's a specialist book which I have, Rook and Ward, which is specialist sexual offences one. Their chapter on Section 41 is really good. There are no shortcuts. You've got to do the work. You've got to look at the case law. And so that's the best advice I would give. So follow the rules in terms of what should be in the application, and take your time on it, think about it, and just make sure you're on top of it. And just remember, it is a really difficult piece of legislation. And the way I always approach this, and perhaps any legal application, which is that you cannot expect the judge to do your job for you. You can't expect the judge to make your life easier. You have to be in a position, if you are applying to do something which requires judicial leave, you have got to be in a position to demonstrate to the judge why the law says this is okay. The amount of people who don't think that way is quite surprising, actually. But my view is always, I'm not going to expect the judge to just nod. I think you've got to be in a position,
Yeah.
basically, not expect the judge to help you, to expect for you to be in a position to say, this is what I want to do, this is why I want to do it, and this is why the law says I should be allowed to. And that sounds really simple. You'd be amazed how many people don't do it.
Okay, perfect. And in terms of, whilst we're on the advocacy topic, in terms of advocacy skill sets then, in rape trials or sexual offences cases, what type of advocacy do you think, what type of skill set do you think is really required in those type of cases? So I remember a little bit back early in the podcast, you said that, the prosecution want people who've got those requisite skills. And what skills do you think in terms of advocacy or skills in general is required?
What, in terms of generally, or Russell cases?
In Russell cases, yeah.
Russell cases, I think you need to have empathy in these cases. I think you need to realise that you're dealing quite often with very, very damaged people who may have had very, very difficult backgrounds. I think also preparation. I know that sounds a bit cliche, but there's just no substitute for being properly prepared for any case. And I think also being able to put witnesses at ease, I think that's quite important with Russell cases, more so potentially over other cases, because, no one ever wants to have to go into a room full of people they've never met, which is reality what these people are doing, to discuss things which, frankly, you wouldn't discuss with members of your own family. Yet you're having to discuss the most intimate details of your life in a very forensic environment, in a room full of people you've never met. And I just think one of the skills you need is to, when you're prosecuting and defending, I think you need to realise that these are people, they're real people, and just treat them with people. Just be nice. You can defend people perfectly well and be nice, genuinely. You don't have to be horrible to be a successful, effective defence advocate. Just be nice. Just realise that these are people, and just treat them with a bit of respect. I think also, one of the skills you need is to know when to give on things and when to say no. This, in terms of things you might be able to agree with the other side. But that comes with experience, knowing what sort of stuff you need to argue about with the judge, or the stuff that you can let go. What you certainly should never do, and I think this is a really, really important skill for any barrister in any case, is you've got to focus on the points that matter. Don't think you've got to argue every conceivable point every single time. Just it's about focusing on what the points that really matter. And that really applies to both sides. So I hope that helps.
Yeah, I think touching on what you said about just treating people as human beings, I had the privilege of seeing that firsthand when I did my mini with you, and the way you dealt with the complainant in that case and the victim, and the family that was along with that person as well. And it's just such, I think people don't realise it's an umbrella of roles, isn't it? It's not just, you're not just going in there as a specialist in the law, you're going in there as so many different roles as well. And I know on Chambers' website it says that you've got experience in handling vulnerable witnesses specifically, and that's just like a skill set that you can take into all walks of life as well, can't you? If you see somebody having a mental breakdown, you'd know how to assist them and help them and comfort them. And it's the same in I guess being a barrister as well. I obviously can't speak for definite because I'm not one, but I think the question is would you say that's fair to agree with, really?
Oh yeah, definitely. I mean, the skills you require to be a barrister go way beyond what we do in court, go
Mhm.
way beyond just being a good lawyer. Um, particularly if you're doing criminal law. I think
Mhm.
that's where criminal law stands apart from other areas of law. It's the human element, which not saying that you don't get that in other areas of law, but you get it day in, day out in criminal law. Whether you're defending or prosecuting, it is such a human system. You're dealing with the extremes of human behavior on a daily basis. You're dealing with really vulnerable, damaged people on a daily basis. You're dealing with some really, really difficult people on a daily basis, and that's just
Mhm.
barristers. No, I'm joking. But um, and so you're absolutely right. I think the skill set is also how you are able to deal with people.
Mhm.
And yeah, I think it's important that you can deal with people. And I think that's become more and more important as time's gone on, because there was a time when barristers didn't go and meet witnesses before they gave evidence or anything like that. Not so long ago. I mean, whereas now, it's unthinkable that a witness would come to court and wouldn't get to meet the prosecution barrister beforehand.
Mhm.
Sometimes they get to meet the defence barrister. So, yeah, I think having the ability to deal with people is really, really helpful.
Mhm. And is there a certain not script, but is there a certain thing that you rely on when comforting people? Have you got a certain way about doing it, or have you got something that you stick by?
I mean, I think we've probably all got our
Our own,
line.
yeah. I'm like a hugger, so I hug everybody. It's really
But
concerned. I judge marshals, and I hugged the judge, and he was like, "Get out your hands off me."
I'm not. I've never hugged anyone. I've had a few hugs at the end of a case.
Yeah, okay.
That's always after a positive outcome, whatever side you're on. They
I
don't
think that's
tend.
what I was doing with the marshalling experience. I think I hugged at the end of it, thinking like this has been the best week ever. Hugged the senior resident judge, and I think he had a bit of a heart.
Oh, but like I say, I think I don't have a standard script that I use. It depends on the witness.
Okay.
Obviously, how I speak to a child is different to how I speak to an adult. Um,
Oh,
but like little things like sometimes like little kiddies, I let them try my wig on and things like that.
oh,
Just like little things like that.
yeah.
Or but no, I don't think I can. I like to think I'm a bit more natural than that. I don't. I just
Yeah.
gauge it. I just judge the mood when I'm in the room,
Mm,
because all witnesses, some witnesses are very unemotional, very cold, very, they're just here, they just want to do it. Where some witnesses are really emotional, and you do need to calm them down and all of that.
yeah.
What I do always say to them is, look, you've got to. This will not be anywhere near as bad as you think it's going to be. um, and you don't ignore anything you've read in the newspapers or anything like that. And but I'm also honest with them. What I always say to witnesses, generally speaking, is this isn't easy. I said, you wouldn't believe me if I said it was going to be easy. I said, we do our best to make this as easy as it can possibly be. I said, but what I also say to witnesses, I says, all we're asking you to do today is to tell the truth. I says, where the truth takes the case is for other people to sort out. All you need to do is tell the truth. And just to try and take the pressure off them to say, look, there isn't any hidden agenda here or anything like that. We don't mind what you say as long as what you say is true.
Yeah. Just make the task as simple, make a really difficult, horrible task as simple as it can be.
Absolutely. And, you
Right.
know, I think the frustrating thing with witnesses is that what every witness really wants me to tell them is, do you think he's going to get convicted? Do you think we're
Yeah.
going to win? you
You
know,
can't.
and that's a conversation you just can't have under any circumstances, because one thing you can't do is ever discuss their evidence with them, or what questions they're going to be asked, or anything like that. You just can't do it. There are very good reasons for that, and I always explain that to the witnesses. I always say, we can't talk about the case. I can't talk about your evidence, so I can't talk about the questions you're going to be asked, because first and foremost, I don't know, because the defence don't have to tell me. But I said also, you've got to understand, we can't be, we don't want to be accused of trying to influence what you say.
Yeah.
So what I tend to do is I always tend to explain it to them why I can't talk about those things, so that they at least understand that it's not that there are good reasons for it. And in fairness, most witnesses get it, because quite often police officers have already been down that road with them, because the police have to be really careful in terms of their interaction with them. So quite often witnesses do get it, but yeah, no hard and fast rule, depends on the witness. But I do have certain standard things which I do deal with. And what I do say to most witnesses is, look, all we need, just try and relax. I know this is going to be difficult, but what we need from you today is, in fact, quite easy, and that is just to tell the truth.
Yeah, absolutely. And what do you think, off the back of that, are some of the biggest misconceptions with rape trials or RASL cases, and actually getting it into the courtroom? For example, I think a lot of people think that they're going to be annihilated by the defence barrister. And like, from what I saw that day, the defence barrister, when I had my mini with you, was very, very sensitive, and didn't annihilate the person at all, and actually just ask the questions, which is the job that obviously the defence barrister is there to do, of course. You can't just not obviously do the job. But yeah, what would you say the biggest misconceptions are?
I would say one of the biggest misconceptions is, you've really touched upon it early, and that is the way people think the system will treat them. I'm not going to sit here and pretend that the system is perfect, or that the system couldn't improve. But I don't think there's any system that isn't capable of improving. We've got delays at the moment in the system, which is a real problem. But, and it's a big but, my view is, once we get there, and once we're there, and it's the trial, and witnesses are giving evidence, my overwhelming experience is that people are treated fairly. Not saying they're not going to be asked difficult questions. At the end of the day, it's a trial. And, that's what the trial process has to allow for, those difficult questions within legal limitations to be asked. But my overwhelming view is that people are treated fairly, and it is really, really unhelpful if it is suggested otherwise, because then that might deter people from going through what is already a very, very difficult process. It's a really difficult process to go through. Of course it is. But I feel that once we get there, once we're in court, people are more often than not treated very fairly. Judges are very rigorous at making sure they're treated fairly. We've already touched on Section 41. The rules are so strict in terms of what they can be asked about previous sexual behaviour and things like that. People have this image of going to court and effectively, a defence barrister just being able to stand up and say, well, you're a slut, you're this, you've slept with 15 men in one night, and you've had 17 boyfriends, and you've had 16 one night stands. People have that image in their mind that that's what they're going to be subjected to. It's just not allowed. It's just not done. It's just not what happens. So it's not easy. I'm not going to suggest that to anyone, that it will be that it's an easy process to go through, but I don't think it's anywhere near as bad as sometimes people think it's going to be. And I think that's the main misconception around how rape trials are. They're difficult. They can be brutal processes, because it's just the nature of those type of offences, and the nature of the things sometimes people are having to talk about. But I think defence advocates sometimes get a very, very unfair press in terms of the way they behave and the way they deal with witnesses. And like I say, I would never suggest the system's perfect, but I think people by and large are treated fairly. And I don't think anyone really can expect much more than that. You know, they just, if someone's treated fairly, I don't think they can really have any grounds for complaint.
Yeah, I agree, definitely. And in terms of some of the difficulties in prosecuting and defending these type of trials and cases, in terms of evidence, would you say it's just because sometimes there's just no forensic evidence, and is that one of the overriding problems?
One of the problems is the nature of sexual offences is, and this is why, and it's not going to change, because the reality is a lot of sexual offences are committed in circumstances where, in reality, there are only two people who know what happened.
Yeah.
That is just the nature of sexual offences. Sexual offences do not often occur in circumstances where there will be a witness, or who'll say, "I saw." Someone glasses someone in a nightclub. You may well have three people in the nightclub who saw it happen, and that becomes a very strong case. You might have CCTV of the person glassing the other person, or that sort of thing. Sexual offences just don't work that way. There are cases that occur in circumstances where you get some CCTV, but they are few and far between. More often than not, these offences occur in circumstances where there just isn't anyone other than two people who know what happened.
Yeah.
And that, yes, that doesn't mean you shouldn't prosecute it. Juries do convict on the basis of one person's word. I've seen it happen, but sometimes they're just not willing to. And that's not a problem with the system. I certainly don't think we should be starting to talk about sort of trying to apply some sort of lower standard to sexual offences. We just have to recognise that they're difficult, and they're difficult because quite often there isn't what I would call a silver bullet in terms of killer piece of independent evidence that shows that the defendant is definitely guilty. And that's just the nature of it. And I think, you hear about conviction rates and things like that. And I think it's really, really unhelpful to try and conduct a statistical evaluation of what are really, really difficult cases. And then when you feed into that, you've not just got one person's word against another, but when you feed into that, the fact that, sex cases, by their very nature, you're often dealing with the complexity of human behavior, human reaction, human emotions, the complexity of relationships, the complexity of consent, the complexity surrounding sexual relationships. You've got to recognize that these cases are just difficult, and they're difficult for all of those reasons. And that's why I don't really like this, or the conviction rates this, the conviction rates that. And, you sometimes get some ill-informed politicians, sort of claiming to be experts on rape trials and saying this, that, and t'other. And obviously there's certain politicians who obviously really do know what goes on. But, sometimes you hear and you think they don't know what they're talking about, and it's actually really unhelpful. I don't like trying to apply statistics to what are really difficult, sensitive cases. And it's no one's fault. It's just the nature of those types of offences. And it's just the way it is. And that's not going to change. Sexual offences will continue to be committed in circumstances where more often than not, there's only two people who knew what happened.
And the last thing a society anyone wants to be doing is trying to put people who have been victims of these crimes off going forward, and having no lack of hope or anything in the system. So when people rave on about how, or there's no good going ahead with it because he's not going to get done for it anyways, or she's not going to get done for it anyways, it's just really disheartening, because it's totally case by case. And like you said, if there is only two versions of events and those two people get to say their version of events, it's completely down to the jury, and there's nothing else that can be done about it. I agree. I see that a lot as well on LinkedIn. It's like the Facebook of like law world.
No, but LinkedIn's as good a place as any. But what I do one thing we should never all lose sight of as well, though, is naturally a lot of what you hear in the press is very much weighted in favour of victims and prosecution. You also have someone who, been convicted of a sex, you, you know, all sorts of people end up in the dock accused of sexual offences.
Mm-hmm.
And, it's not what you think. I defended a university student 2 years ago. He was a secretary university student for rape. And it was a really highly pressurized case and all of that. And, it's all people of all life. And you should never lose sight of the fact that there's also someone in the dock who is entitled to a fair trial, whose entire life is likely to be defined by that conviction. So the process has to be fair to both sides. And by and large, I think it is. I think some would argue that we've maybe started to tilt too much in favour of the prosecution in these cases. But by and large, I think juries get it right. That's my experience.
Yeah, and I guess the jury are the only people who can return the verdict, so you have to be not always have to be happy with what they return the verdict on, but you've got to have a little bit of hope that in the criminal justice system, it's the right approach, and it's the best system that we probably could have could obviously be a bit better, I'm guessing, but it also, just a couple last questions. I read the written piece that you did for the criminal briefing on the res gestae.
Res gestae.
Res gestae.
You were very close, Ellie. Res gestae.
I've learned something new there. The res gestae. So, do you ever see actually that in cases where there's been an allegation of a domestic rape? So, say for example, wife is raped, husband's raped, wife or boyfriend or girlfriend or whatever. Do you ever see that evidence used in? Because if I'm right in understanding, correct me if I'm wrong, that evidence is, say, for example, somebody is now unwilling to cooperate with the prosecution, they can still bring the CPS can still bring the case under this is it legislation law?
It is now. It is now. I mean, just to quick explain it. Res gestae.
Yeah.
It's been around for decades.
Mm-hmm.
It's not new. In summary, it's supposed to cover spontaneous outbursts, so where people say things where they're said to still relatively overwhelmed by what's happened to them, that the possibility of them having made the whole thing up is quite low. So, it's that spontaneity, and that's sort of been watered down a little bit, but it still has to be, for it to be res gestae, it still has to be what they've said when it's relatively close in time to the core event. The further away you get, the less likely it's going to be res gestae. Okay. And what's really changed and what's been a game changer. So res gestae isn't new. Res gestae has been around for decades.
Yeah.
When the Criminal Justice Act 2003 came into existence, which effectively modernized the law and the rules in relation to the admissibility of hearsay evidence, res gestae was a common law exception to the rule against hearsay that was preserved by the Criminal Justice Act. And what has effectively happened is that has coincided with the introduction of body-worn videos, which police officers now have. So what is happening is, and more often than not, it's in the context of domestic assaults. So effectively, X rings the police, or X's neighbour rings the police and says, he's just beat me up. Police turn up, you're there, face covered in blood. Yes, he's just beat me up. This is what's happened. This is what he's done. They're injured and all of that. This is all recorded. All right. So then you've got that. And then, as can often happen in those sorts of cases, they decide they don't want to proceed, probably because it's their boyfriend who says they're really sorry and they'll never do it again, or for whatever reason. Mm-hmm. Crown Prosecution Service actually have a policy where they have to take a really robust approach in domestic offences. And so quite often that won't be the end of it. And what the law has basically allowed, and what the direction of travel is that you can actually use these recordings as evidence, albeit the prosecution would have to justify why it was they weren't calling the witness. And one of the things that is really important, as far as I'm concerned, is the fact that it used to be that they said, "Oh, well, the witness is available, so why can't you just bring the witness to court?" But what the court said in a case called Barton was that actually that's not the way we should be approaching it, because res gestae assumes that the witness is available. So the witness doesn't have to be unavailable to resort to res gestae, because there are other provisions which you can rely on if the witness is unavailable, whether that be dead or whatever. So effectively, to cut a long story short, the direction of travel is very much in the right circumstances, the court being able to use this. So to answer the question you posed originally, I personally haven't encountered it in a rape case yet, but I can't see any reason why, in the right circumstances, you couldn't try and rely on that sort of evidence. But you would have to, but the prosecution, of course, they can't just be gung-ho about these things. You've got to act responsibly. So the first thing I would expect to have to do in that situation is to be in a position to justify why we weren't calling the witness. And one of the things that this case called Vilhetti, which came after Bart, which made it clear that they chose not to compel the attendance of the witness in that case because of mental health concerns. And what was basically concluded was that is a rational decision that the prosecution have made, i.e., it's a decision that they can justify. We've got to be careful, because we've always got to recognise that it'll always be second best hearsay, and that we're always in a position where, and no doubt people will argue, and I don't entirely disagree with them, that this is effectively of preventing someone being able to fully challenge the evidence against them, albeit in domestic abuse cases that doesn't necessarily work, and that's what happened in Barton. What the court said was, well, he can call Mrs. Barton if he wants to. Whether that's the way it should be approached, I don't know. But so I think the direction of travel is that this is here to stay. Res gestae evidence is something which the courts are becoming increasingly comfortable with, in my experience, and there is no reason why that couldn't happen in a rape case. But the prosecution would have to act responsibly and carefully. And, like I say, just because you can do something doesn't mean it's always the right thing to do.
Yeah.
And you've got to be in a position to describe. I think the first thing you'd always have to justify is, well, why aren't you calling this witness?
Yeah, okay, that makes sense. Rather than just relying on that piece, like you just said, because you can do so. Okay, brilliant. Thank you for that. That was really interesting, actually. So I obviously clearly interpreted that completely wrong. To see my attempt of trying to ask that question was hilarious. So, proudest moment in your career then?
It's probably a case I prosecuted about 3 years ago.
Yeah.
Obviously, I'm not going to name it on him, but effectively, it was a man who ended up representing himself. Was faced. It was like horrific abuse of two separate girlfriends, sexual abuse, physical abuse, controlling coercive behaviour, blackmail, threatening to, if they didn't do what he wanted, he would post images of them online and things like that. Horrible, horrible case. It sticks with me for various reasons. The first reason is one of the and I mean, she is a victim now because he was convicted. One of the victims, her recorded interview with the police when she sat down speaking to the police to basically tell them what she'd been through, was one of the most harrowing things I have ever watched. And I'm a sort of hardened, experienced barrister, but I still remember watching that. and I found it really, really difficult to watch because he'd just completely broken her in so many ways. And her account, the way she was, it was just harrowing to listen to. And the jury obviously agreed because they convicted him. But what became interesting was how much of a control freak he was, because he kept falling out with his various legal teams and ended up representing himself. So an advocate had to be brought in to cross-examine the two complainants, because that's the rule. Defendant is not allowed to cross-examine someone in those circumstances. But then he represented himself, and he was just vile from start to finish. He was vile to the judge, he was vile to me, made all sorts of allegations. And it was a really challenging case, a very challenging case for all sorts of reasons, not least that I was dealing with an unrepresented defendant facing really serious offences. And he was convicted, and he was sentenced to life imprisonment because the judge took the view that he was such a dangerous individual. And proudest moment, I think it is just, it was the right decision. And I feel the world's a slightly safer place with this individual in prison for the foreseeable future.
Now, question off of the back of that then. So say, for example, he did decide to have legal representation. You happen to be his defence barrister. And in that, as a human being, not as a barrister, watching that footage, the same footage that you've just described there, the harrowing footage, and obviously still putting forward a defence case if he had instructions for you, of course, to the best of your ability, not taking anything like personal, I understand that. But watching that footage and seeing the jury return a verdict, which you have to believe that they've returned a correct verdict, would you also still walk away from that, do you think, as a defence barrister, thinking, do you know what, fair enough, because he's a monster?
I would walk away thinking, I think the jury got that right. I can understand why they've convicted. Whether I would have that conversation with myself, possibly. Yeah, I mean, we're only human. I mean, when you defend people, you recognise that sometimes you're defending very, very unpleasant people, who are potentially quite dangerous. But I think it's very difficult. I mean, I've defended in cases like that before, and I do my job. I do my job properly. I do it within the rules. I always, someone I'm representing, I always make sure they get the best possible chance they could possibly have. But within the rules that I have to work by. And as long as I've had a fair trial, I walk away and I think, well, I can live with the outcome. As long as it's been fair, and usually it is. I don't know if I don't know if I answer the question, because it's a difficult thing to answer as to how you would feel in a situation you haven't been feeling. How would I felt walking away if this guy had been convicted? It's a difficult one to answer.
It is hard. I think it was more just off of the fact of watching the footage, but of course, and this is where the two sides of the story come into it. It's perception, isn't it? What he thinks might be justifiable. Obviously, a jury have found it's absolutely not justifiable behaviour at all, and he is just obviously a really dangerous person. But obviously, your client, you would obviously go on what the instructions are. So I know it was a difficult question, but I just thought I'd ask.
No, it's absolutely fine. Yeah. Yeah. I'm not sure. I do sometimes sit and wonder what it would have been like to have to try and represent this individual, how I would have approached things. But fortunately, I was on the prosecution side this time.
Yeah, absolutely. Well, and I think my final question for you would just be, in terms of problems that the more specifically RASL cases are facing at the moment. You touched on the fact that there's delays, shortage of resources. What real impact do you think this is having on victims and defendants as well, or those accused? Sorry, rather, I should say.
Yeah, well, I think delay is one of the big problems we've got in the system at the moment, and it's not just once it gets to the court system. I think there's delays, and I think the investigations take too long. Albeit this isn't me bashing the police. I think it's just because there aren't enough of them. These are really paper heavy. They're very front loaded in terms of the level of preparation, and sometimes it just takes. A police officer who's got like 30 of these cases ongoing, and that's a hell of a lot of work. So don't for one moment interpret what I'm saying as a criticism of the police. But I think the lack of resources within the police means that these cases take longer than they really should to get to court. And then when they get to court, then we've got further delays in terms of, the very famous backlog that we have in terms of how cases are being listed, cases now being listed in 2027, and it just means that what is going to be a really difficult process for everyone involved. And this is the same for defendants, because I think one thing that's an absolute outrage is the fact that someone can be released under investigation. You imagine, you're interviewed for rape, and then you have to wait for 4 years to know whether you're going to be charged or not. You've got trying to we often focus on the prosecution and the effect on victims and that, and of course that's correct. But I think that is an absolute disgrace that someone can be can be released, or the released under investigation provisions have just been a license to delay, a license to prolong. And yes, that's equally going to be felt by victims. But imagine 4 years of your life not knowing whether or not you're going to be charged with rape. And I think that's a real problem in the system. It's something I feel very strongly about. I just don't think it's right.
Yeah, and that could give so much rise to other problems like mental health issues. Oh my goodness, some people without probably doubt will probably kill themselves in that period of time if they can't cope with it anymore.
I mean, fortunately, I've never been in that position.
Yeah,
but you wonder what it must be like to be in that position. And then there's the effect on victims and things. Delay, I think, to be fair about it to everyone, it doesn't help anyone. And I think it's a big problem. I think the amount of delay we have in the system at the moment, it's a problem. And I think it's probably the biggest problem that we have.
Yeah. Okay, well, Lee, thank you so much. So just to wrap it up then, a little bit of motivational advice for somebody who wants to be a barrister and maybe feels like they can't do it. What would you say to
them? That people from all walks of life become successful barristers. Work hard, remain humble, listen to advice, be willing to make mistakes as long as you learn from them. And one thing that I always say to every barrister is that it's not for everybody. You have to recognize that if you're going to be a barrister, particularly at the independent bar, that it is not a 9 to 5 job. It is not the sort of job where you can go to work at 9 o'clock, clock off at 5 o'clock, have all your weekends and not expect to have evenings or weekends interrupted. It's not just you can't have a work-life balance. I'm not suggesting that at all. But I think people always have to be realistic about what they're signing up for. And it's a job that will impact every area of your life. But if you're willing to deal with that, you're willing to work hard, learn, then you'll no doubt have what it takes.
Okay, amazing. And can all of the viewers and all members of the audience give you a follow on LinkedIn and all the rest of that?
Yeah. More than welcome to.
Yeah, thank you so much. Well, thank you so much for this evening. And yeah, obviously, really enjoyed it. Hope you're still eating the Percy pigs from last year as well.
Okay, well, that's absolutely fine. Yeah, and thank you for inviting me on, Ellie. And good luck with your future guests.